Hi, greetings. It's me, Dr. Paul Gerhardt, and today I wanted to give you another human resource lesson. This is fresh off the press from the SHRM magazine online, written by Roy Maurer. And what I love about this March 1st, 2019 article is that we learned some lessons about hiring, some things that maybe many of us as employers kind of take for granted and may not be realizing that we could be in violation of some EEOC expectations. So let's talk about that a little bit. Of course, the EEOC stands for Equal Employment Opportunity Commission. And if you're in the human resource world, this is something that we're dealing with all the time because it's really important. The EEOC is about protecting people's human rights, and especially in the workplace. So it basically was a commission put together to make sure that employers were doing the right things for the right reasons, for a lack of better words. So in this case, I got to fix the E here. In this case, there was a recent settlement. So there was a lawsuit that took place where UPS got sued. And they got sued for failing to hire and promote people based upon religious accommodations. Interesting. So you'll be surprised, perhaps, with the findings here, because the religious accommodations had to do with appearance, particularly facial hair and hair length. Interesting. So they were found guilty of failing to hire or promote people based upon religious accommodations. The company policy prohibits male employees in supervisory or customer contact positions, including delivery drivers, from wearing beards or growing their hair longer than hair length. So according to this article, the allegations were that the suit included Muslim applicants being told they would have to shave their beards for driving positions. A Native American man was told he'd have to cut his long hair in order to be hired, and Rastafarians were denied positions due to the length of their dreadlocks. The EEOC further alleged that UPS, as a matter of policy, hired employees who maintained beards or long hair in accordance with their religious beliefs into non-supervisory, back-of-the-house positions without customer contact. So the EEOC stance, according to Kevin Berry, the director of EEOC's New York District Office, said that the alleged conduct violates Title VII of the Civil Rights Act of 1964, which prohibits employers from discriminating against individuals because of their religion. Federal law requires employers to make exceptions to their appearance policies to allow applicants and employees to observe religious dress and grooming practices. So let's look at the legal requirements. So once informed that a religious accommodation is needed, employers accommodate an applicant or employee who sincerely held religious belief, practice, or observance conflicts with a work requirement, unless doing so would pose an undue hardship. So you have to really be thinking about that undue hardship thing. He explained that undue hardship under Title VII has been defined by courts as imposing more than ordinary administrative costs or burdens on the operation of the employer's business. So from the employer's perspective, customer preferences, even the anticipated loss of business, doesn't constitute an undue hardship. For that reason, employers may not, when making hiring decisions, assign new hires back to a back-of-the-house position because of actual or feared customer preferences. The EEOC maintains that such decisions violate Title VII's prohibition on limiting, segregating, or classifying employees based on religion. He said it does not matter if the employer is following a uniformly applied employee policy. Rather, the employer must make an exception to its policy or practice as a religious accommodation. So really maybe a paradigm shift that even though you're thinking about the customer and you're thinking about the business, people can adapt, obviously, but violating someone's religious expectations in making a hiring or promoting position is still illegal. So the lessons learned here, and I will try to paraphrase this, recognizing that issues will often be encountered first by frontline managers and supervisors. Employers should provide training to managers and supervisors, explaining that the law may require making religious exceptions to an employer's otherwise uniformly applied dress or grooming rules, practice, or preferences. So it really is important to recognize that sometimes we had the old ways of doing things and we've just always done it that way, but recognizing that we may have been violating people's human rights for a long time. And so that's why we have the EEOC in place to help employers make sure that they're making the best hiring and promoting positions in a legal way. And so this helps really clarify what those expectations are in kind of an interesting manner, don't you think? All right, this has been a 6-minute video, and I hope that this has been interesting to you. It certainly has been interesting for me to kind of read the findings of this lawsuit that took place and remind you that as a human resource professional or a future human resource professional or someone in a leadership position, try to make sure that you understand the laws and minimally, but more than anything else, recognize biases and manage diversity in a way that makes a workplace equitable and absolutely fair, because our people are the things that make our organization strong. But you, as a leader, help create a culture that will either effectively manage that or not. So think before you act. Thanks so much for taking time to watch this video to the end. I hope that you've taken something away from this of value. And more than anything else, I hope that you have a great day, because only you get to choose how you feel about it. I'm Dr. Paul Gerhardt.